all rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Madam Court Officer, please call the case.
Good afternoon, Your Honors. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Salimi, and Jakub Kresnici.
Good morning, everyone, good afternoon, everyone. I note that Mr. Kresnici is attending today's status conference via video link. The other accused are present in court today. I also note that Ms. Alekandra and Ms. Rowan are attending via video link. We wanted to have a short status conference in order to outline our present intentions as to continuing this case and to get your comments and suggestions. And perhaps more importantly, to hear if there are any unresolved problems before we move to the next stage of the trial, beginning with the Defense Preparation Conference scheduled for right after the end of the summer recess. This conference is not a substitute for the Rule 119 hearing, which we still intend to hold as scheduled. This conference is, like many other conferences which we've held during the trial, to get a reading on the progress and the planning that's going on with the teams. We look forward, as always, to hear your comments. A written agenda was circulated on Friday. The panel will do our best to address the 7 points in the agenda in the order set out in the agenda. Before turning to the first point on the agenda, the panel will issue an oral order concerning the classification of the Defense Rule 130 motion and related filings. On June 12, 2025, the defense filed a motion pursuant to Rule 130 with filing number F03256. On 16 July 2025, the panel issued in public session its decision on F03256. Pursuant to Rule 82, paragraph 5, noting that the F03256 was filed confidentially and to ensure to the extent possible a public trial, the panel orders the defense to request the reclassification or to file a public redacted version by F03256 by no later than Friday, 22 August 2025. The panel further notes that in filing F03314 on 7 July 2025, the SPO requested the reclassification of filing F03314 and its annex as public. Upon review of the relevant filings, the panel grants the SPO request and orders the registrar to reclassify F03314 and F03314/A01 as public. This concludes the panel's oral order. I note that Mr. Misitich, representing the Thaçi defense, requested via email to be heard at the outset of the status conference on the scheduling of the defense case. Mr. Misitich, you have the floor.
Thank you, Mr. President, and good afternoon, Your Honors. I rise just to raise a few matters that will inform the answers to all of the questions you've posed to us, and so I don't repeat myself later on. We can set them out now. But with respect to how the timing has transpired in the last 6 weeks or so, I'd like to just restate for a second our understanding of the procedural history here. At a status conference on the 22nd of January, 2025, at transcript page 24342 to 24343, the defense was asked how long a defense case may take and how much time the defense preparation would need between the issuance of a Rule 130 decision and the commencement of a defense case if such is necessary. And the joint response of all four defense teams was a request for 10 weeks from the issuance of a Rule 130 decision, excluding the summer recess. At the next status conference on the 19th of February 2025, at transcript page 25462, the Vaselli defense and Mr. Dixon asked the trial panel whether the guidelines we had asked for at the January status conference for the time for preparation of the defense case was broadly acceptable to the trial panel, and the response from the trial panel was that they're broadly acceptable. The defense was thus expressly told by the trial panel in mid-February that the defense's joint request for 10 weeks from the trial panel's Rule 130 ruling, excluding the summer recess, was broadly acceptable to the trial panel. That is the basis upon which we have been preparing the defense case, and the panel gave us no indication from February to June that anything had changed. On the 5th of June, 2025, the panel issued, without hearing the defense and without notice to the parties, a revised scheduling order, an F03232, in which the panel proprio motu set deadlines for aspects of the defense case, including the provision of witness and exhibit lists on the 21st of July 2025 and the holding of a defense preparation conference for the week of the 21st of July. On the 13th, as you know, we filed a joint request for variation of the schedule, citing reasons why to vary the time limits. On the 23rd of June, the SPO responded to our request, objecting to the variation. In addition, the SPO requested the panel issue new orders regarding timeframes for entirely new issues, including fulfillment of disclosure obligations pursuant to Rule 1045, and providing information required pursuant to paragraph 74 of the Order on the Conduct of Proceedings. The defense filed a joint reply on the 27th of June, reiterating the good cause underlying our motion and objecting to the SPO request to impose new deadlines. One of the rationales advanced by the defense was the defense should have a fair opportunity to be heard on proposed deadlines that seek a significant variation of the requirements under the rules. On the 2nd of July, the panel issued its decision F03302, largely denying our request for variation of the deadlines, except for a variation of the date for the defense preparation conference. The panel also imposed many of the additional deadlines requested by the SPO without substantive submissions from the defense, and issued several additional deadlines. Pursuant to that order, the Thaçi defense, as the first defendant named in the case, is ordered to be ready to start presenting its case on the week of the 25th of August 2025. The trial panel with this decision reduced the time available to the defense to prepare its case from 10 weeks, which would have put us roughly at mid-October to start the defense case, October 15th to be precise, that the defense had requested in January and February, and which the panel had said was, quote, broadly acceptable, and reduced it to 2 weeks and a few days. All of this was done without notice from February to June, and all without having heard from the defense about the difficulties the defense would have meeting that short of a timetable. Our submission is not adequate for the panel to say that we did have an opportunity to be heard because you heard us in October and January and February and April, because the defense specifically requested the trial panel's view of its 10-week proposal and was told that that was broadly acceptable. If the panel later decided that it needed to reduce this to 2 weeks, then the accused had a right to be heard. Moreover, the accused were entitled to rely on the panel's broad acceptance of the 10-week request, i.e. roughly mid-October defense start date, when it was making arrangements between February and June for the preparation of the defense case, including in the timing of its applications to Rule 107 providers. On a related note, I must add that the panel's abrupt reduction of the defense preparation time from 10 weeks to 2 weeks has caused significant personal hardship and disruption to the lives of the members of my staff, who for weeks have been working 12 to 15-hour days plus weekends to try to meet these new deadlines. We are unaware of the trial panel or the pretrial judge ever treating the SPO in this manner, imposing new disclosure deadlines and dates of commencement of the SPO case without giving the SPO an opportunity to be heard. For the record, we formally object to not having been heard on these new dates, which have caused significant reduction in the time for preparation of the defense case. And we request, as we discuss the rest of this timing schedule, an opportunity to explain why we are not going to be able to meet some of the deadlines, at least as we, from the information we have right now, from the Rule 107 providers. So, thank you.
Anybody else?
Your Honour, I simply want to join those submissions and say that at the hearing on the 23rd of April, at page 26167, Your Honour's expressly recognised the efforts that all parties have gone to in the case to date to keep this case moving and to comply with deadlines. My team, like Mr. Misicic's team, have been working absolutely at capacity in order to meet the deadlines that Your Honours have set, and I pay tribute to the work that they have done. And we join the submissions of Mr. Misicic as to why, starting the defence case on the 25th of August, we are not going to be in a position to do that, and I'll be able to explain why as we go through the course of the agenda.
Thank you, Mr. Ellis. Prosecution wishes to respond?
Briefly, Your Honor, just to say that the discussion of the 10 weeks, in our view, needs to be superseded by what the defense actually asked for when they were confronted with this schedule. In the 13 June 2025 request, what the defense said is the defense anticipates being able to call its first witness in the weeks starting Monday, 15 September 2025. That is within 30 days of a defense preparation conference held in the week of 18 August 2025. That's a lot less than the 10 weeks. That's what they asked for, and as indicated in our email yesterday, that time is necessary for us as well in order to prepare. And we think that that would be sufficient flexibility in these circumstances.
Thank you, Mr. Laws. Do you have any comment?
No, nothing to add. Thank you, Your Honour.
Anybody, anything from the panel? Any questions or comments?
Well, maybe so that the chronology you gave, Mr. Misicic, is complete. On the 1st of October of 2024, you were asked how long you thought you would need to prepare your case, and your answer was, and I quote, about 6 weeks, 4 to 6 weeks to make sure we can line up in our witnesses. So that was on the 1st of October of 2024. And the other matter I would wish to raise with you, Mr. Misicic, was the time that was required for the Rule 130 application. The rules provide for 10 days, and pursuant to your application, we granted the extension that was requested, and you ended up having 6 times the time frame required by the rule. May I take it that at least some of the preparation for the defense case were done during that period?
So, in answer to each point, October is obviously way before all of the subsequent status conferences where additional time was posed, and as I said, the panel indicated that it was broadly acceptable, the 10-week frame. The second issue is, yes, of course, we've been working with all the time available to us. However, that still doesn't change the fact that we're operating under the regime that we thought had been agreed with the panel in February, which was 10 weeks. And I also wish to clarify, I have not asked now for an extension to mid-October. I'm just saying, so that you have the context here, we've been operating under the assumption that we would have until mid-October to start the defense case, that if we thought maybe the panel would shorten that time a few weeks, but not 8 weeks, and putting us in, at the end of August.
Again, for context, Mr. Micetic, these discussions at the time were in the context of that period of time that included the 130 motion. If my calculation is correct, between the time when the prosecution closed and the time when you would be expected to commence your case, you would have 4 months of preparation time, of course, in full understanding that you have spent some of that time dealing with the 130 motion. And I've done a little exercise of comparison with other cases of similar sizes. Quite frankly, I could not find any or many that would be as generous, including some cases in which you, Mr. Micetic, had been involved. So my question, perhaps to you, putting it that way, is how long do you expect, or did you expect you would get from the time when the prosecution claims to be ready to start your case?
So, as I've said, first of all, I don't know what other cases you're referring to, but I don't think we had this many Rule 107 providers that we needed clearance for. That's the first issue. The second issue is I would have a question back to you, which is if that was your thinking, I'd like to know why we weren't told that in March or April or May, but were told that for the first time on June 7th, that you thought we had too much time.
Well, I don't think I need to answer your question, but my assumption, right or wrong, was that you would spend the time that you did not need for the 130 motion to prepare your case, which I heard from you is precisely what you did. And the case I had in mind was, for example, in the Gotovina case, where you called 25 witnesses. You got 2 weeks, not 6 or 8 for the 98 bis 130 application. 10 weeks between prosecution case and start of defense case, not 16 weeks. And exactly the same amount of weeks, 7 weeks between the no case to answer decision and the commencement of the case for, as I understand, half the number of witnesses. That's one of the cases I had in mind.
Okay, and my question again to you is how many of those witnesses in those cases were Rule 107 providers, or the equivalent thereof under the ICTY? The point is, we have, of the witnesses we have disclosed to you under rule that don't require Rule 107, we could start the defense case, but we're talking about 2 witnesses. And I shouldn't say that because we could start it by the date
3.
we proposed. No, one is a 153 witness. So we have 2 witnesses. Whether it's feasible to bring them by August 25th is an entirely separate issue, which we can get into when we start this. It depends on WIPSO.
It sounds as though the primary problem with your preparation is the 107 witnesses.
Exactly.
And I have to remind you that 2.5 years ago, Mr. Keogh stood about where you are, telling us that he would like to bring those witnesses in right away, out of sequence, prior to the defense, or prior to the prosecution's case. Did he just make that up, or did he have permission to use their names in the court and say that he wanted to call them?
We have received correspondence from 107 providers saying they wanted to further clear. And so now we're in that process of it.
If he wanted to do it right away, when was it that he was going to clear?
Frankly, I wasn't there at the time, so I was. But the reality of it is,
But that's your team's statement that happened at that time. I think it was the first day we were in court that he brought that matter up.
Okay, but again, we have.
A little confusing to us that 2.5 years later, you're telling us that you still haven't got a clearance.
And
Apparently that could have started 2.5 years ago, the process.
And for the record, Mr. Micetic, the difficulty is that the process in relation to at least half of the proposed witnesses started in October of 2022, half of them. So if we're being told now 3 years down the road that they are still pending 107 issues that are holding up the case, it's a bit hard to to comprehend. And I will come to the legal aspects of 107 in a second, but that's a complete chronology of things. These started in October of 2022, and then in January of 2023, again, the same list was put for us. Two-thirds of them at the time are the same individuals as we are dealing with now.
Well, again, there are reasons for that, some of which are there's a difference between clearance for interviewing witnesses and a clearance for use at trial. Second of all, some of these witnesses have follow-up that we do with them because, of course, we listen to the prosecution case.
But they were being offered as witnesses, Mr. Micetic. I went back to the filings. They were being offered not for, clearance was not being discussed for the purpose of interview. We understand the difference. They were being offered as witnesses back in the days.
Judge, if you can get them here over the objections of the Rule 107 provider, that's fine with me. But let me just, again, I'm sorry, I have to reiterate this. If this was your thinking and you were going to shorten the time, all I can say is we relied on what we were told in February. And why we weren't told that you're not going to get that amount of time between February and June is still unexplained to me.
Sir, Mr. Micetic, just so the record is clear, I just want to read a little bit from the filing of 28th October 2022. And it suggests that paragraph 33, all of the potential witnesses that the defense has been in contact with are available in February 2023, apart from one who's available in April 2023. And so my question is simply this. When did the process of seeking Rule 107 clearance from the relevant providers commence?
So there are various stages of seeking Rule 107 clearance. There were stages earlier in this case where clearance was sought but only obtained to interview the witnesses. Sometime in the spring of this year, I don't have the exact dates, when we knew that we wanted to call some of these witnesses at trial, we submitted formal requests to these providers to clear them for the additional portion of it, which is to testify.
But from the filing of 28th October 2022, it appears that on that date, your team did want to call those witnesses to testify.
My team did want to call them. All I can tell you as an officer of the court, they have not been cleared yet to give testimony in court.
Thank you.
The application process was a bit dilatory. It should have happened quicker. There's no question about that.
Again, if we're, we can call it dilatory, but I can only represent that on the schedule that we thought we had in February, we hoped that we are going to have these people cleared by the 15th of September.
But you don't know that. You don't know that even. I'm sorry. You don't even know that even today.
Of course, because it's up to the Rule 107
So what are you going to do on the
providers.
15th of September if you haven't gotten it?
I'm going to
cleared?
come back to you and say we don't have clearance, or in the meantime, and we've tried this once before on an ex parte basis, shortly we're going to go to the panel and ask for your intervention.
Mr. Ellis, anything you want to add to this?
Your Honour, can I simply add for the record that and I think this was a point made in our filing F3258, it's obviously not simply a case that we've been working on the Rule 130 motion and then working on defence case. There were, at the time we filed that motion, some 44 other filings from the defence, an equivalent number of filings to consider before drafting those responses. It really isn't the case that the defence have been sitting waiting. There has been an awful lot of work going on behind the scenes here.
We've been doing some of that ourselves.
Of course.
Ms. Alejandra, do you have something you want to say? Okay. Anything else from up here?
I have, since we are on the Rule 107 issue, Mr. Micetic, I have some concerns about your interpretation of Rule 107, and I want to ask you about it to be certain that I understand exactly what you are saying. I understand you to be suggesting, and I refer to your filing of yesterday that came to us this morning, F03357, that's your submission of yesterday, 21st of July. I understand you to suggest that either you are not authorized or not required to provide the names of prospective witnesses that are subject to 107 clearance. Do I understand that correctly?
It would be not authorized. I would not say not required.
And do you have any authorities for that suggestion? I've seen in your submissions, I think it's in footnote 8, that you are relying on the position that the prosecution had taken in respect of one witness. And I wanted to know whether you had any authorities for the proposition that you are not authorized to disclose these individuals.
Frankly, I didn't know I was going to have to research authority, so I'd have to go back and research it. The issue is not really whether it's a legal issue. The issue is whether, from our perspective, we weren't invoking a legal, in other words, an international criminal law precedent, but rather our understanding of the Rule 107 providers' positions.
But am I right that in October of 2022 and again in January of 2023, you actually disclosed half of these names to the SPO, the pretrial judge, and the panel?
Judge Mitro, the issue is whatever happened in the past, if it was done incorrectly, doesn't mean that I can continue to do it incorrectly. And the providers have indicated as such to me as the current specialist counsel.
But whether it's incorrect or not, I think it's our determination to make, Mr. Micetic. The problem is you are now trying to argue, as I understand you, that there's a prohibition to disclose that information when the information has already been disclosed to the opposite side. So
I'm not trying to argue anything. I'm trying to work as cooperatively as possible with Rule 107 providers to get these witnesses here. If you wish to issue an order ordering me to disclose it, obviously I will comply with the order, but to the extent that that causes any additional difficulties with Rule 107 providers to get these witnesses here, then that's an issue that the trial chamber will have to, or the trial panel will have to bear some responsibility for.
Well, that's why I'm offering you an opportunity to tell us what the legal basis or the authorities would be. And if you want to answer that, there's also a submission that you make in your submission, paragraph 4 of your submissions of yesterday, that summaries of the proposed witnesses are, in your view, premature. Now, again, I will have the same question for you. You already have disclosed some of these summaries of at least half of the proposed witnesses. What's premature about the disclosure of that information? And I mean 2.5 years ago.
I will have to repeat myself. If something was done incorrectly 2.5 years ago, does not mean I can continue to do it incorrectly.
When was the last time you had some communication with the 107 providers?
We have them almost on a weekly basis, and as of yesterday, to be prepared for this, I tried to urge them all what's their position, and the response I got was, we're working on it, we have nothing new for you.
And they don't give you any kind of a timeline?
No, but I can assure you that we have conveyed the 18 August deadlines and urged them. The response we typically get is it's in some institutions an interagency issue and the bureaucracy and getting it to move, et cetera. One of the things I'm going to raise here is that now to ask them to move over these summer recesses, I worry that it's going to be even harder to get these interagency people in the bureaucracy to coordinate in an efficient manner. But again, I don't have any inside information as to how those processes are working.
I hesitate to even ask this, but Mr. Ellis, would your team be in a position to lead off the questioning of witnesses first so that Mr. Misitich's team can wait further information from the 107 providers?
No.
Pardon?
No.
Okay.
We would not. I can go into further details, but I can go into further details if you require, but that's my straightforward answer.
Is sufficient. The panel will now turn to address the first point on the agenda, which is on July 16th, 2025, the defense for Mr. Thaçi and Mr. Krasniqi respectively informed the panel pursuant to Rule 119.1 that they each intend to present a defense case. Further, the panel notes that yesterday on Monday, 21 July 2025, the defense for Mr. Thaçi and Mr. Krasniqi filed their witness and exhibit list pursuant to Rule 119, Paragraph 2, which is filing numbers F03357 and F03358. The panel would therefore like to confirm with the Thaçi and Krasniqi defense that the documents filed yesterday constitute the entirety of the documents the two defense teams would like to file pursuant to Rule 119.2. Mr. Mistich, you can lead off on that first.
Yes, we have filed a list of witnesses and a list of exhibits which satisfy the requirements set in Rule 119.2, but only to the extent that the items or individuals did not require clearance pursuant to Rule 107 of the rules.
Yes, we understand that.
Yep.
And I'll ask you a follow-up then. Do you intend to tender all of those exhibits, or are they merely some tendered and some on hand as needed?
It's the latter.
Any idea how many at this time you intend to offer with witnesses?
I'll be perfectly candid, Mr. President. We got your order on Thursday, and with the volume of work involved, we have not had a chance to go through now those kinds of specifics.
And do you anticipate using the bar table for some of your exhibits?
Yes, we do.
Any idea on number on that?
No idea. Part of it's going to depend on what we get in through our witnesses and what's left over.
Okay. Mr. Ellis, do you want to answer the same questions?
Yes, I think it's a broadly similar pattern. We have filed our list of witnesses and list of exhibits. We don't at the moment envisage needing to file anything further. Looking at the list of exhibits, a relatively small number would be tendered through witnesses. The rest would either be bar table or are there or may not ultimately be used. We would anticipate filing the bar table. We haven't yet decided whether it be one large bar table or whether we would split it into smaller ones. But given that at least one bar table would be a residual category, it would come towards the end of the defense case.
I didn't ask you that, Mr. Misitich, too. Is that likely to be the pattern for your tenders as well?
I'm sorry, let me just read the transcript.
Are you going to save a good number of them to the end and offer them at that time?
Yes, the last day of the defense case.
Yes.
Thank you, Your Honor. We'd like to make a few submissions on this agenda item, if that's all right. Yes. So, first, in relation to the witness list, I think this is clear already. The Thaçi witness list is not a meaningful preparation document for us. There's only 3 witnesses whose names that we can see. Everything else is redacted. The first person on the list, when read against paragraph 5 of FO 3357, it's clear the Thaçi defense has not even contacted this person yet. And incidentally, a witness that we are no longer intending to rely on, we would say the contact protocol doesn't even apply. They're responsible for the logistical arrangements.
May I ask for a redaction of that from the transcript, please? We asked in the filing for certain information to be confidential.
You want the entire statement redacted?
The
filing is confidential, Mr. Misitich.
I've tried not to reveal any confidential information in my submission.
Yes, but just the portion that says witnesses we are no longer intending to rely on.
We'll take that under advisement. Go ahead.
To finish on the list of witnesses, we can't meaningfully prepare for the defense case as matters currently stand here. On the exhibit list, we had 2 points that we wanted to flag that I think are common to both of the exhibit lists that we received today. The first is that we would argue that it is not best practice to have cross-references within a list of exhibits. Both of the defense teams cross-reference to the entire SPO list of exhibits in addition to their own. Rule 119.2b requires a list of proposed evidence the defense intends to present. And it would be more helpful, just as a working document, if the list of exhibits was actually a complete list of the universe of items that the defense may tender during their case. They actually have no real authority for the proposal that they have. The Thaçi defense cites to one case in their motion. It's an ICC case talking about exhibit lists for the pretrial confirmation of charges hearing in the Gichiro case, which has no resemblance to either the features of this case or the current part of the proceedings. And it's not procedurally comparable to a big case like this one. The last point that we wanted to mention in relation to the list of exhibits is, with the limited time that we have had, it's quite clear that not everything on these lists of exhibits is translated into English. In particular, although Rule 102.3 and Rule 103 items, when the SPO discloses them, we are not obliged to make an English version. In order for these lists of exhibits to be meaningful, there has to be an English language version if they are intending to tender it into evidence. And this would need to be remedied as soon as possible, both of these lists of exhibit issues, in order for this document to be a meaningful preparation document.
Judge Mitro has a question.
Thank you. And I'll start with you, Mr. Harling, if I may. I'll ask the same question as I've asked Mr. Micetic in relation to Rule 107. Is there any bar, in your view, legal or otherwise, to the defense disclosing to you the name and summary of proposed evidence of a witness subject to Rule 107 clearance?
Our position would be that this is a provider-by-provider issue. The reason why we didn't provide the name of our Rule 107 witness in the example in the footnote was that was clearly expressed by the provider. But it can't be implied by the provider. It has to be a meaningful restriction. And it's frankly not clear from the Thaçi defense's argumentation if this is in fact what the providers really want. If you look at paragraph 4 of the filing FO3357, there's a comment that should statements not be cleared, the defense may instead be required to call witnesses live, which would necessarily increase the time required for direct examination. Well, if non-clearance of the statement means that the people are coming live, that suggests that the names can be given to us. And we need every name that we can as soon as possible in order to meaningfully discharge our obligation to prepare for these witnesses.
Thank you. And I have a question, or a couple of questions for the defense. Thank you, Mr. Harling, which pertains to the exhibit list. The first is there's common language to both the Thaçi and Krasniqi's submissions of yesterday that refers to Rule 119 and indicates that these are the exhibits that you may use or present at trial. The language of the rule is not may, it's that you intend to present. Now, assuming what you said, Mr. Micetic, to be correct, that there's an element of buffering, if I may use that expression in your list, and it's only fair enough. The concern that I have, at least, is whether the mind of counsel has been put to whether or not you intend to use the bulk of that material, and that it's not just a dumping exercise of 4,916 documents in one case and above 1,000 in the other, and that I can be reassured that some consideration has been given that you intend to use at least the bulk of that material. The second thing I would like to get some clarification from you is about these SPO documents. I wasn't entirely clear about what your submissions are in that respect, so I would like to be a bit clearer. Is it that you haven't included in your proposed exhibit list the documents that already appear in the SPO exhibit list? And again, if so, what's the authority for you to claim to be permitted to do that under the rules? Because the rules appear relatively clear to me. It says that you have to provide the list of the proposed exhibits that the defense intends to present.
Again, we adopted an approach that, again, that intends to use is a rather broad category. They are documents that we would intend to use in the right circumstances. They are not going to be all affirmatively dumped into the record. I would note that the SPO exhibit list has 21,000 items, of which 8,600 were tendered. So roughly 2/3 were never tendered. So I'm not sure what the SPO being in a position to claim prejudice, but the defense was put on the position of tens of thousands of documents that ultimately were never used in the case. We are, I don't think, doing anything that hasn't been the practice of the SPO, and in many respects, we tried to use the SPO as a guide to how we should put together our defense case. There is one issue I wanted to address.
You haven't reassured me, Mr. Micetic. I don't think you can have it both ways. I don't think you can criticize the prosecution on the one hand, and you may have good grounds to criticize them, to have a list that's way too long compared to what's eventually tendered, and then justify your own conduct by that. The reassurance I'm seeking from you is that careful thought has been given to the list you've placed before us last night, and that with all the qualifications and all the buffering that we understand might be necessary at this stage, careful consideration has been given to the fact that this is indeed what you hope or intend us, to use the expression
I would
of
say,
the rules, to
in response
tender.
to that, careful consideration is a term that may have worked under the time that we thought we had. But under the compressed schedule that the panel surprised us with in June, every hour available to every person on this defense team has been working, as I said to you, 12 to 18-hour days plus weekends. So that's all I can say to you. If you'd like us to go and trim the exhibit list, we can go back and do that. But I am telling you that there's only a certain amount of hours in a day. And particularly if you're going to crunch us on time, when the prosecution had 10 years to prepare its case, and now suddenly 4 weeks has become a serious issue for this panel.
And the second issue, Mr. Micetic, the SPO documents. I wanted clarification, if you want me to repeat the question. I wasn't entirely clear, and in particular I have to say about the submissions of Mr. Krasniqi. If we are to understand that you've given, in effect, yourself the possibility of using, or you're asking to be permitted to use any document that was on the prosecution exhibit list without having to list it on your own exhibit list, is that how we have to understand your submissions?
Yeah, the problem is, again, you put us under a time crunch. And so we've put, to the extent possible, SPO documents from their exhibit list on our list. But the exercise of moving those documents then into a defense exhibit list and into legal workflow, et cetera, is a huge, and I just have to say it, a huge consumption of time that we don't have. So this is a way for us to ensure that we can use the documents and get additional time to sift through whatever else is going to be included. But again, the whole exercise of putting stuff in the legal workflow, as we explained in the filing, is time that is not available to the defense.
And Mr. Ellis, same position on SPO exhibits, or are you, maybe I'll ask the question differently, is every SPO exhibit or every document that was on the exhibit list that you intend to use on your list?
No, it's the position as set out in the filing that we are seeking to keep the possibility of using documents that are on the SPO's exhibit list but have not been included on our list of exhibits. This was an attempt to be helpful rather than an attempt to be unhelpful in the light of the large number of documents on the SPO's list, which all the parties are on notice of and have been throughout these proceedings. To re-give notice of documents that the parties were all already aware of and prepared for, we thought time was better directed towards providing a list of documents that the parties were not already on notice of. So we've tried to be helpful rather than unhelpful, and to get a list together in the time that was available to us. Can I say also that in answer to your first question, yes, in the time that we have had, we have carefully considered the items on the list, and that I know when I say that we may not end up tendering all of these items through a bar table motion, but I can say, as an officer of the court, yes, we have carefully considered and done our best at this point in time.
If I could just add on the legal precedent, it has been the panel's precedent that all the parties are on notice of all documents that have been disclosed, or the defense has been on notice of all documents that have been disclosed to it, such that the panel can use them without notice in judicial questions. And so it seems a little different then that if we then notice the same documents, and if we were expected to be ready to go without any notice, including without an exhibit list before a witness, then it failed to see what the prejudice is to anyone else.
There's no suggestion of prejudice, Mr. Micetic. I'm trying to find out whether these are the documents you intend to use. That's all. Just trying to understand what those are.
Yes, and I forgot to address one point that Mr. Halling raised, which is I have made the specific inquiry about whether we can disclose the names of the witnesses to a Rule 107 provider, and I haven't even gotten an answer to that. So in the absence of an answer to that question is why we're being cautious. Again, I emphasize, I don't want to do anything that will upset a Rule 107 provider, and that's the reason we're being cautious.
I have a question for Mr. Halling. This concerns the issue of potential prejudice to the prosecution. Now, as you know, the defense is bound by the order on the conduct of the proceedings. So for any material the defense wants to use, with a viva voce witness, they must give you advance notice. For any material they want to tender as associated exhibits, they must give you advance notice. And obviously, if they file a bar table motion seeking admission of certain exhibits, you'll know exactly what the exhibits are. So given that there is this secondary level of notice, very specific notice, of the exhibits that the defense genuinely wants to tender during trial, my question is this: does it make any real difference, the fact that the defense has sort of tried to incorporate the entire prosecution's exhibit list in this way? Are you really going to be handicapped in any way in responding to and objecting to specific exhibits that the defense wants to use?
Thank you, Your Honor. The proposal that we made is really more based on just efficient trial management grounds. We're familiar with the items on our list of exhibits, even the ones we decided not to tender. But it's just for the orderly conduct of the proceedings to have one master document of all of the items that could potentially become exhibits in this phase of the case. That's our understanding of the value of having a list of exhibits, rather than just every item disclosed in the case being potentially fair game. It has a specific trial purpose, and it's unlike a situation with a presentation queue where the interest might be a little different in terms of whether we need to have duplicated all of the things on one presentation queue into others. There is an interest in having a kind of global single document where all of this stuff is contained. And that's all that we are asking for. It's just a matter of refiling this list of exhibits with whatever additional documents they seem to already have in mind from our list of exhibits duly included.
Thank you.
Sorry, but I should probably be wiser than this, but I just have to repeat. Where was that argument when we were complaining about the judges using anything that's been disclosed? There was no master list of judicial documents that might be used. So there was no prejudice to anyone, and particularly a finding that there's no prejudice to defense. So I'm not sure what a master list now, how there's any prejudice from that, or lack of.
The next issue that the panel would like to address. Oh, Mr. Ellis, I'm sorry.
Your Honour, if I may, there was one other point Mr. Halling raised, which I didn't address, which was the issue of translations.
Say that again.
It was the issue of translations that Mr. Halling raised that I hadn't addressed. Although Your Honours will have seen it's foreshadowed in our cover filing, in fact. There were 3 documents on our list of exhibits that do not currently have a translation. We're on it, and we'll disclose translations as soon as we can.
Yes, and to be clear, Your Honor, I wasn't referring to those 3. I'm referring to what seem to be many others beyond those 3 where there's no equivalent explanation.
And our position is the rules provide specifically for a prosecution obligation to disclose a translation under Rule 1021. There is no reciprocal obligation for the defense to disclose a translation in the rules.
All right, the next issue the panel would like to address is that of witness-related filings for the upcoming defense case. Following yesterday's submissions, the panel would like to confirm with the Thaçi and Krasniqi defense first of all, how many live or Rule 154 witnesses they expect to call during their case, and 2, the evidence of how many witnesses will be tendered under Rules 153 or 155. Mr. and Mrs. Tix, you can go first on this.
Yes, thank you, Mr. President. At this stage, we intend to call 12 witnesses, 11 of whom are anticipated to testify in court. However, we can currently only confirm the 3 witnesses. 1 witness is anticipated to testify fully viva voce. The next step will be provision of information required by paragraph. No, that's
So who is the
a
viva
witness
voce?
who's been disclosed.
Okay.
Yeah. As of right now, the one witness, the one other witness that has been disclosed is a 154 witness, and then the 3rd witness that's been disclosed is a Rule 153 witness. I would say for most, if not all, of the remaining witnesses, we expect to file a Rule 154 application. But again, all of that is subject to clearances and
Thank you. That's very helpful. Mr. Ellis?
As set out in our filing, Your Honours, it is 5 in total, 2 for whom we anticipate filing Rule 154 applications, 2 Rule 153, and 1 Rule 155.
Thank you.
Yes, and Your Honor, if we could be heard on this one briefly. If we could just be heard briefly on this agenda item. Yes, so just one thing that we wanted to confirm at this point, just because it's arisen in other trials, is just to confirm that on the defense presentation that none of the accused are intending to testify. So they're not on the list, and that's what that means. We wanted to get that confirmation on the record. We also did want to ask, from the way the dust is currently settled, there are only 3 Rule 154 witnesses, and I know that the panel indicated that they would like it on a rolling basis and at least 3 weeks before the first one came, but given how small the number is at the moment, whether there could be some set filing date for the Rule 154 witnesses that are currently known.
I'm about to get to that. At the Defense Preparation Conference, the panel might set deadlines for any filings under Rules 153, 155, in accordance with Rule 119, Paragraph 3 and 4. It might be helpful if the teams suggest a deadline for these filings so that we can be sure it's feasible for you, and we can then adopt it if possible.
You mean suggest them at the Defense Preparation Conference or now?
No, at the Defense Preparation Conference.
That's fine.
I'm giving you an advance notice so you can think about that a little bit. If you know at this time, that would be fine, but,
I don't, but
Yeah.
we will be ready.
so is that an acceptable? We'll get that date, possible dates for the filings, and then everyone can comply.
Yes, and sorry, Your Honor, just to be clear, my submission was only about the Rule 154 witnesses. So the Rule
Yes.
153 and 55, that can wait, but especially if the court is going to keep hearing witnesses the week of August 25th, we
Okay.
would submit the Rule 154 application should be different.
So what about the 154 applications? When would you suggest you can be ready to file those, bearing in mind that it would be good to have it on file before the Defense Preparation Conference?
Well, our position was going to be, or is, a Rule 154 application for the one witness of the three that have been disclosed will be filed as soon as possible, but no later than the Defense Preparation Conference, along with the provision of information required pursuant to paragraph 74 of the Order on the Conduct of Proceedings.
Is that sufficient?
No. If the hearings are still starting on the 25th of August, our response deadline would still be running when that Rule 154 witness appears. The
We'll
panel
see.
said at least 3 weeks before in
Taking into consideration what you've stated, Mr. Misitich, we'll set a deadline, but it will be dependent upon our decision on the starting date of testimony, all right?
Yes, obviously, if we get what the parties have jointly requested, including the SPO, an extension to at least the 15th of September, then 3 weeks from before that is fine with us. Or even by the 18th of August. For this one witness is a deadline we will meet.
And Mr. Ellis? Do you have any 154 witness?
Your Honor, I don't think I'm in a position to name a date as I stand here. There are
We will endeavor to make a date, giving some advance notice to the date of the start, and we will name that date at the preparation conference to come.
Sure.
Anything else from the SPO?
just if from non-reaction it can be implied that no accused are testifying in the case.
Yes, that is correct.
Yes.
Your Honour, we had set that out in our notice saying there would be no defence case and Mr. Vasili would not be testifying.
I can confirm the same, yes, Your Honour.
In the next point on the agenda, the panel would like to inquire about potential applications for protective measures to be in a position to adequately plan ahead and to ensure the expeditiousness of its decisions. First, do any of the two defense teams presenting a case intend to file applications for protective measures for any of the witnesses they are calling? And if that is the case, are the teams in a position to give us the number of witnesses and a timeline on when we can expect to receive those applications?
As noted in our filing, there is one witness for whom protective measures have been previously ordered, which will continue. I don't know if I should cite you to that order, but I'm sure you're familiar with it. We may request modification of some of these protective measures, including, well, can we go into private session for just a minute?
Into private session, please, Madam Court Officer.
Your Honors, we are now in public session.
Thank you. Thank you, Mr. President. It is currently anticipated that all of our remaining witnesses will not require protective measures, but this is subject to conditions being imposed by Rule 107 providers. So there may be Rule 107 provisions requested by providers. We add the caveat that's in our filing that to protect the privacy and security of the potential witnesses, we propose to maintain the confidentiality of witness identities until the point of their in-court testimony, should for some reason they wish to make a last-minute request for protective measures. Thank you.
And for ours, we don't currently anticipate making any applications. If the witnesses subsequently make any request of ours, we'll bring it to Your Honour's attention as soon as we can.
Thank you, Mr. Ellis. Anything from the SBO on this?
We have no objection to the proposals on protective measures and confidentiality of witnesses. There was something on the previous agenda item, and apologies if I didn't mention it before, just on the order of witnesses that we wanted to put on the record. I can do it now. Obviously, our preparations, the order of the witnesses is very important. At the moment, there's only 4 potential people coming to the courtroom that we know. There's also 1 witness that's called by the Krasniqi defense alone, and we understand from the sequencing that person is last. So we're really just talking about the order of 3 people, and we were wondering if that order could be confirmed now.
The answer is no, because the order on the conduct of proceedings does not require us to disclose the order until 3 weeks before the next session, right? Or is it 2 weeks? 3 weeks. 3 weeks, right. So whenever you set the date for the start of the Thaçi defense, we will have minus 3 weeks from there to give you the order of the witnesses.
Again, given how few people are involved, we don't understand why that's necessary. The key point for us is that if Rule 107 witnesses are cleared, they can't be injected into a point in the order when we don't have a meaningful opportunity to prepare for them.
Mr. President, obviously, if that comes up, I'm sure the panel will ensure that they have a sufficient amount of time to prepare. The issue here is we don't know, A, the travel schedules of some of these witnesses, and B, more importantly, there's at least one witness who we've discussed in private session who it's not up to me, it's up to WIPSO now to make the arrangement. So until I know what is feasible, I can't tell you what the order of witnesses is going to be.
We'll follow the order on conduct of the proceedings and try to implement it exactly as it said. I understand your request. It was reasonable, but if they don't want to comply, I don't think we're going to make them do it under the rule as we adopted it. The next item on the bullets is dealt with bar table motions and judicial notice of adjudicated facts. And I think, unless somebody wants to talk about it more, we've covered bar table to the extent necessary. But I would like to know, as to the second issue, if there are any potential motions for judicial notice of adjudicated facts. And the panel would like to know whether the 2 defense teams intend to file any further motion for judicial notice of adjudicated facts, and if so, by whom and when.
I'm not sure what you mean by whom.
Well, which team is, how many, by team, how many, when you're going to file?
Yes. Again, we do anticipate filing a request for notice of adjudicated facts. We are not able to provide further information at this stage beyond those that were filed on the 21st of July. We will not be able to turn attention to written motions until after the further deadline on the 18th of August. So I don't anticipate it's going to be a lengthy motion, but at this stage, we haven't had sufficient time to give you a precise answer.
Will you be able to answer that at the
Yes.
Defense Preparation Conference?
Yes, Mr. President.
All right, we will expect that. Ellis, Mr. Ellis, go ahead.
Similarly, we'll be able to confirm final position at the Defence Conference.
The next point on the agenda, we've discussed also somewhat, but not totally. The panel would like to inquire if the Thaçi and Krasniqi defenses can respectively clarify as to how many documents and proposed witnesses are still subject to clearance under 107, and what is the expected timeline for the process to be completed. And I realize the timeline is going to be difficult at this point. But how many, let's start with documents. How many documents are subject to clearance under Rule 107?
We are waiting for approximately 30 documents for clearance. They have not, and I inquired yesterday and got a response that was rather vague.
And we've talked about your proposed witnesses. Mr. Ellis, do you have any 107 witnesses?
No 107 witnesses, 5 107 documents.
5?
5 documents.
And have you received a clearance on those?
No.
Okay. Any timeline given to you?
No.
All right.
Yes.
Comments by the SPO?
Some of it we've said already, but in FO 3302, whenever the clearance issue in relation to documents is resolved, the defense are required to disclose on a rolling basis. That's not squarely said the same way for the identities of witnesses once cleared, but especially given the discussion in the hearing, we would ask for that as well.
Thank you.
Mr. President, that's understood on our
There's no
end.
objection by
No.
you? No.
That's fine.
As to the last point on our agenda today, and to ensure that there will be no preventable delays in August, the panel would like to know from the two defense teams that intend to present witnesses whether they are in a position to comply with any remaining disclosure obligations, or if there are any remaining disclosure obligations pursuant to Rule 104, Paragraph 5, and can that be complied with by Monday, 18 August 2025. As set out in paragraph 27D of the decision F03302. Mr. Misitich, you can go first again.
I apologize for being repetitive, but we have complied to the extent we can apply and comply and will comply with all of our obligations by the 18th of August, to the extent we can control that. However, our ability to comply with the deadlines set by the panel is dependent on factors outside of our control, namely receiving clearances from Rule 107 providers. We undertake to complete all outstanding obligations for witnesses and documents that are cleared by the Rule 107 providers by the deadline.
Yes, and if they can't do that, we expect that to be justified with a fully reasoned request explaining their diligence as to how it got to this point. But a couple of other points in relation to disclosure, and specifically with avoiding preventable delays, as Your Honor put it. The first, and this is really more of a question than an objection, but there are no statements that we can see taken by the defense teams on these lists other than formal statements. And as has been discussed repeatedly in this trial, statements are a record in whatever form of anything that a witness said in respects of facts and circumstances relevant to the case taken in the context of a criminal investigation. We appreciate that there are Rule 107 restrictions on some of the statements, and that's why we don't have them. But just to confirm from the defense teams that there are no contact notes, other kinds of information that are not on these lists that we're entitled to. The second point that we wanted to make, certainly.
We'll cover the first one first. Is there any response to that?
Yes, I'm not sure what he's referring to, but our disclosure obligation under Rule 104.5 is to provide the specialist prosecutor the statements, if any, of all witnesses the defense intends to call at trial, and all statements taken which the defense intends to present at trial. All statements which we intend to present at trial have been turned over.
That's already been done.
Other than the Rule 107 witnesses? Yes, yes.
Yes, so if all statements that are intended to be called at trial is already provided, then that would satisfy.
With the exception of the 107.
Correct. The second point is, Mr. Misitich said something a little earlier in this status conference, which is a preventable delay and in the disclosure context. At page 31 of the real-time transcript, he said, Our position is that the rules provide specifically for a prosecution obligation to disclose under Rule 102.1. There is no specific obligation for the defense to disclose a translation in the rules. That position is asking for chaos, because if the defense don't have an obligation to provide English versions of the things on their own list of exhibits, then it is going to become a routine problem during the defense case that items are tendered for admission that no one can understand in the working language of the proceedings. And this is not a situation where the defense is merely providing something that is not intended for use at trial. This is intended for use at trial if it's on the defense exhibit list, and we don't agree with their position that they don't have an obligation to translate this stuff.
Go ahead.
Mr. President, the rules say what they say, first of all. As Mr. Halling is fond of saying, you are the drafters of the rules, and you didn't impose the same obligation on the defense. That's the first point. The second point is I think you know me well enough that I'm not going to tender documents that are not in English and that you can't therefore understand the document. So if we're going to put a document on our queue, it will have an English translation, and it will be disclosed in sufficient time for everyone to be prepared to go to trial. But I understood Mr. Halling at the beginning to say he'd like us now to spend the rest of July and August translating every document that doesn't have a translation that's currently on the exhibit list.
I don't think we need to have a translation of 4,700 documents if they're all in another language. But if they will offer, if they're going to offer a document, it should be translated. I have no argument with that.
That's true, but our understanding was yesterday was the deadline to provide their list of exhibits. And right now, there are exhibits, it's been admitted that there are exhibits on this exhibit list that cannot currently be tendered because they are not currently in a form in which they can be tendered. And we would say that needs to be addressed now in some form in order for the defense case to proceed smoothly.
Well, if they are ordered to not tender any document that is not translated, that should handle the problem. You wouldn't have to have them done tomorrow.
Understood. It then just creates the corresponding, we do need enough time to meaningfully read the document to be able to respond.
Understood.
And this would need to be incorporated.
I'm also advised now that when the SPO produced its exhibit list, there were hundreds of documents that didn't have an English translation. That was in 2022, I believe, 21. And it was even in 2025, they're disclosing translations of documents on their exhibit list 4 years later.
Could you mention to us a date by which the translations could be completed?
If we're talking about what, every document on the exhibit
No, the
list?
documents you intend to tender.
So, again, it depends on, whenever we have to disclose the documents in our queue, we will certainly do it before then. And I would think,
Would it, it's like ridiculous. It's ridiculous. It's a common sense problem, and it needs to have a common sense solution.
well, that's kind of what I was suggesting with my last answer to this, which
Well,
is...
that might be 10 minutes before you put the witness
No,
on
no,
the stand.
that isn't common sense, because I want you to be able to see the documents, most importantly, before we get a witness in the box. So I don't foresee this to be a problem, but if it
How about 5 days prior to the calling of that witness?
that's fine, that's fine.
Is that satisfactory, Mr. Holling?
In a typical case, we can work with this.
Okay, thank you.
Mr. Michetic, I'll try once again to square the Rule 107 circle with you because I'm not there yet. The first thing I want to ask you is this. By my account, there's 9 Rule 107 witnesses currently on your list. Have each and all of the providers relevant to these witnesses asked or requested that you not disclose the identity of these individuals to the SPO. And the subsequent question, if you want to address them both at once, is really the 18th of August. Now, that's the deadline. We've given you with, of course, the caveat that Mr. Halling mentioned of the rolling basis, if and when you get a clearance before that. But what's the current plan if you are not getting clearance for all or some of these witnesses on the 18th? The concern being, of course, that we're going to find ourselves then in the situation we are now, that you're going to tell us you need more time and you haven't received clearance. So do you have already a plan B that you would like us to consider when we make our orders?
So, as I indicated to you earlier, it's a question of interpretation of the language that we were given in these Rule 107 letters from us. I followed up earlier this month requesting clarification of what is the position and have not received a response. So, in the exercise of caution, until I get that response, we have not disclosed the names. Because in the ambiguity, I don't want to err on the side of over-disclosure. The second thing is, with respect to the 18th of August deadline, as I said to you earlier, my intention is, very shortly, if we don't hear from them, you will get an application requesting the panel's assistance. And that will be before the 18th of August.
Thank you.
Mr. Misicic, just on that point, I take it you are in correspondence with and have a cooperative relationship with each of these particular Rule 107 providers that you're referring to right now?
We are in correspondence with all of them. With some of them, we are in actual oral communication as well.
So we're not talking about a situation of uncooperative providers, are we?
There may be one, but I don't want, I'm just say that more out of concern at the pace rather than any expression of opposition or
Let me put it this way. Are you fairly confident that you have agreement in principle that these individuals will be able to testify?
I am, and so that's why my concern here is that no one has indicated to us any suggestion that they won't be cleared. It's just a question of how fast are they going to get them cleared.
Thank you.
And hence, it's related to Judge Matro's question. Obviously, if circumstances outside of our control, we get to the 18th of August, and you will get an application from us, because we're not going to just give up on it, and we're going to ask, let me stop for a second. The panel is aware on an ex parte basis that there is one provider in particular who is giving us a problem, right? And we've asked for your assistance. We're going to go back to you again for assistance with that one provider. But with respect to the rest of them, they have been cooperative. They do want to produce their witnesses. They just say that they need internal processes to finish.
And as appropriate, I assume you're in contact with the registry.
Yes, absolutely.
Thank you.
Your Honor, given the submissions, we appreciate that there's a limit to how much we can know about these Rule 107 issues. But the panel can know, and given the submissions being made, we would strongly suggest that the panel get an ex parte submission from the defense explaining exactly what their full efforts are in this regard and what the specific restrictions the providers have imposed.
If, so far all morning, I've heard the SPO ask to impose conditions on the defense that, of course, they never, in their wildest dreams, would have thought for you to regulate how they were contacting Rule 107 providers. And so I fail to see what the issue is here. You've set an August 18th deadline. If there's an application from us at that point, then we can litigate the issue of whether we've exercised due diligence. But in the meantime, I assure you, these are witnesses we want to call. They need to come because they have relevant evidence, and we're going to seek the panel's assistance as part of our exercise of due diligence to get you to help us get these people here.
Before leaving this agenda item, it was brought to my attention there was maybe a possible ambiguity in a previous answer. We just wanted to confirm once and for all. Rule 104.5, talking about disclosure of prior statements, talks about both the disclosure of statements that the defense intends to present during their case and also any statements they have of witnesses that are on their list. Mr. Misicic mentioned both strands of it in his answer, but then his last part was all statements we intend to present at trial have been turned over, and I see him shaking his head. So I wanted to clarify if the statements of the witnesses that they are want to call, but they do not intend to present at trial, have been disclosed.
The answer is the rule is quite clear that it's the only statements we have to disclose are those we intend to present at trial. The wording of the rule is to produce the statements, if any, of all witnesses the defense intends to call at trial and all statements taken which the defense intends to present at trial. Meaning, we have to produce the statements of all witnesses who are coming into the courtroom, as well as the statements like through 153 or 155 that we intend to present at trial. Not that we have to present the statements of every statement of every witness we intend to call. And if we're going to get into that, then we have all sorts of other issues, including the right against self-incrimination and what the obligations are of an accused. We raised this in the pretrial as well.
That is all that's on our list. Before we conclude today, the panel would like to know whether there's any other issue that hasn't been discussed that you would like to bring up. Any party.
Yes, Johannes, can I ask, in light of the recess coming up and the fact that there are going to be the need for filings, for certain of those filings to be delayed until after the recess. None of these concern the defense cases, which we can fully understand have to continue given the deadlines that are there. But it concerns 3 victim submissions. And we have just emailed Mr. Laws on this to see if he has any objection to that, but he can be asked now. The first one is in relation to the response to F03349. That's the request for reconsideration, whether our response could be extended until Monday the 25th of August. That's a week after the end of the recess. And then there are 2 others as well, which are still to be filed this week. It's the request for adjudicated facts from Victims' Council. That's due on the 24th of July. And then the 153, 155 applications, which we understand Victims' Council are going to submit now on the 25th of July. So if those could also be extended until the 25th of August to respond to, and then, of course, replies thereafter. So that they don't interfere with the recess period. I understand that's been the practice previously. And this concerns just the victim's case, not the defense cases. Thank you, Your Honours.
I don't object to that at all, Your Honour. Thank you.
We'll take that up and make a decision. Thank you for your attendance today. We will be happy to see you in August. Did you have something else? Oh, okay. We're adjourned.
Your Honours,
Mr. Gullis.
just in the light of the submissions that have been made, it would be extremely helpful to have an indication of Your Honour's position on what was a joint proposal for moving the start of the defence case to the 15th of September.
But all.
I apologise. I've got out of the habit of leaning in towards the microphone. My fault. I was just asking, in the light of the submissions that have been made, it would be helpful to have an indication of the panel's position on what was a joint proposal for starting the defence case on the 15th of September.
That's something we have to decide, and we will decide, and you will get a written order on it.
Very well.
We're adjourned.
All rise.